In this video, we're going to explain how attorneys charge fees in estate administration or probate. But I want to start by telling you what we're not going to cover in this video. We're not going into great detail about what all is involved in estate administration because I have a video dedicated entirely to that exact topic, which I'll link below if you're interested in checking it out. So for this video, we're just going to assume that you have a general understanding of what all is involved in estate administration. So let's get clarity on the different fee structures so that you can gain a better understanding of how attorneys charge fees in estate matters. At the end of the day, at least where I practice in Pennsylvania, attorneys' fees are governed by law under what's called a reasonableness standard. So in Pennsylvania, attorney fees are always subject to review by the courts. And there's case law that guides the court in determining whether a fee is reasonable. So it's going to be helpful for us to look at this case law because it will set the stage for determining whether a fee that you've been quoted is fair and reasonable. In La Rocca Estate, the Pennsylvania Supreme Court outlined various factors to be considered in determining the reasonableness of compensation sought by an attorney for his or her representation. The factors include, number one, the amount of work performed. Number two, the type of work performed. Number three, the difficulty of the problems involved in the estate. Number four, the amount of money or value of the property in the estate. Number five, the degree of responsibility incurred. Number six, the professional skill and standing of the attorney in their profession. Number seven, the results that he or she were able to obtain. And number eight, the ability of the client to pay the fee for the services that were rendered. Now let's cover the four common types of fee structures for estate administration. So we have hourly rates, we have flat rates, we have a percentage of estate assets, or some type of hybrid billing structure, which we'll talk about at the end. And this is personally the way that I prefer to charge fees, and we'll talk about why that is. Now, I just want to note here that executors are also entitled to a fee for the services that they provide. And just like attorneys' fees are governed by a reasonableness standard, so too are executors' fees. And in many types of billing, executors' fees and attorneys' fees are tied together in some way. So they're usually reflective of the amount of work that the attorney or the executor does on behalf of the estate. So I'm going to break down how each of these structures work and why they may be good or bad for the client or the lawyer. And I want to be clear about this. I have my preference, and I personally think that it is well reasoned, but there are absolutely pros and cons to each, and there is not a perfect solution. There's no one-size-fits-all billing solution, and that's because every estate is different. So the most important thing that you can do is to choose an attorney that you trust, and ideally someone who focuses most or all of their practice in this area, and someone that can provide value in the services that they provide. First up is hourly rates. This is pretty straightforward. The attorney has an hourly rate. Often the paralegal and other staff members may have hourly rates, and they keep records of the time that they spend working on a particular estate. And if you're working with an attorney who performs hourly billing, they'll often send you periodic invoices, or at least will do that if you request them, just so that you can get a sense for how the fees are tracking throughout the process. Hourly rates vary widely depending on geographic location and experience of the attorney. So you may see anywhere from $250 on the low end, all the way up to $700, $800 an hour at high-end firms in major cities. Let's talk about pros and cons of hourly billing. There's a good argument, at least on the surface, that hourly rates are the best way to ensure that the rate is tied to the actual work that goes into the estate. The other positive of hourly billing is that you can look at the invoice and you can see exactly what work was performed, so you can know within reason that the fee is tied to the actual work that was performed. There are certainly attorneys who use this billing method, and I'm not trying to start any wars here, but I personally find that hourly billing is not always the best for the client, and it's not always fair to the attorney. For the client, they may have no sense whatsoever for what the bill is going to look like, and they may be very surprised to learn at the end how much the fees were and what they're actually paying. I've tried hourly billing, and I find that clients are generally much more conscientious, and this can make things challenging if the client doesn't want to call you to ask questions, or if they're trying to do things on their own that maybe they shouldn't. So, for example, we handle all of the accounting for an estate in-house, but to save money in an hourly billing structure, I've had executors that wanted to process payments for bills on their own. They've wanted to handle making deposits and keep the accounting records. And accurate record keeping is essential for proper accounting of the estate. And when it comes time to prepare tax returns and a final accounting, we found a lot of essential information missing. So then we had to backtrack, occasionally request records from the banks. And aside from adding to the time, this caused a delay in finalizing the estate. My biggest issue with hourly billing is that it doesn't account for all of the work and time that goes into building out an efficient law firm, a firm that's able to effectively handle every estate that comes in. So, for example, we have very expensive case management software, and this makes us more efficient. It cuts down on potential problems, and it helps us manage each case better. We've spent an unbelievable amount of time working on process improvement, training staff, creating client tools to improve their experience, and none of this is reflected in an hourly rate. I once heard an attorney say it this way: if you had the choice between two surgeons, both billing the same hourly rate, and one of them was using the latest technology, they were better trained, and they had a better team behind them, so they're capable of completing the surgery in half the time, would you pay the other surgeon with less training twice as much for work that was less efficient? And one of my favorite quotes, and it applies to almost everything in life, is price is what you pay, value is what you get. So personally, I don't like hourly billing, but there are many attorneys who do hourly billing. So as a client, if this is more attractive to you, then there are definitely attorneys who will accommodate this billing model for you. Next up is flat rate. So a flat fee is a predetermined fixed amount that an attorney charges for the estate administration process. The benefit of a flat fee is that the client knows upfront how much the service will cost. For attorneys, it's nice because they don't need to keep track of their time. Unlike hourly billing, the fee remains the same even if the process takes more or less time than anticipated. There are no surprises or escalating costs. There is, however, a potential for overpayment. So if the case turns out to be simpler or quicker than expected, the client could end up paying more than if they were billing hourly or if the attorney were billing hourly. But the opposite is true for the law firm. If more work goes into the estate, the firm could end up losing money. And assuming that the work is done properly, they are not capturing the true value of their services. Flat fees are more common for relatively straightforward probate cases or estate administration cases where the attorney can pretty accurately estimate the amount of work that's going to be involved. So this could include handling relatively small estates or simple estates. A flat fee can be a great option for clients who want the security of knowing exactly what they will pay from the very beginning, but it may not be the best fit for more complex estates where the workload could be unpredictable. The next type of billing structure is a percentage of the estate. Traditionally, in my experience, the most common type of billing, at least where I practice in Pennsylvania, has been based upon a percentage of the assets in the estate or some variation of a percentage-based fee. Most estate administration attorneys are familiar in Pennsylvania with what's called the Johnson Schedule. The Johnson estate was a case in Delaware County Court of Common Pleas, and it's been widely adopted by many practitioners across Pennsylvania as a standard billing structure. It shares the same general benefits as a flat rate in the sense that there are no surprises. The client knows what they're paying up front. The client knows what the fee structure is going into the case and can make a judgment call as to whether or not they feel that that's fair. So I'm going to take a moment to show you the Johnson schedule. So the Johnson schedule sets forth fees for executors and attorneys. And you can see that it is a percentage-based structure that's sort of a sliding scale. So focusing on the attorney's fees, you'll see that there's a larger percentage for the first $25,000. And then as the size of the estate or the assets in the estate grow, as the assets increase, the percentage that's billed decreases. You'll also see that there are some special categories for non-probate assets, for joint accounts, for real estate, and things like that. While this structure has been sort of tried and true, it's not without its criticism. The structure may work very well in certain cases, but it can be totally out of whack in other cases. And this cuts both ways. Sometimes it would be wildly unfair for the client, and sometimes wildly unfair for the attorney. So I'll give you an example. Imagine an estate with $5 million in assets, and these assets are tied into one single cash account. Now, I know that this hypothetical seems unrealistic, but bear with me because I think this will make a lot of sense. So even though there are substantial assets in terms of value, handling one account may be very easy, and the law firm may not be doing a ton of work in that case. So based on the Johnson schedule, the fee for this estate is definitely too high. Now, in another case, you may have $200,000 in assets, and the assets are spread over numerous asset classes, and the estate is a total mess. So let's say there's a car, the executor can't find the title to it. There's a cabin in another county that's dilapidated and needs to be sold. There are some very small positions in stock that are registered with a transfer agent that the attorney has never heard of, maybe some U.S. savings bonds, and let's say there's a lot of debt, credit card debt, medical debt, perhaps medical reimbursement or Medicaid reimbursement to the state. So you can use your imagination and come up with a relatively small estate that is a complete disaster. And you can see how things can get a little lopsided one way or the other. When it makes sense, I personally like a percentage-based fee structure because it gives the client an understanding of the fees up front, similar to a flat rate where there are no surprises, no escalating costs, and it protects the law firm if there are unknown assets that crop up after the fee agreement is solidified. There are a lot of things that can come up that can add tremendously to the workload that may not have been anticipated at the time that the fee agreement was signed. So this can be a win-win. So I sort of take a hybrid approach. I typically like the percentage structure, but if it doesn't seem to fit a particular case, we can do one of two things. One, we could adjust the percentage so that it works out. So for example, the percentage might go up if it's a particularly messy estate, or it could go down in a relatively simple estate. The second thing that we can do, and I do this sometimes, although less frequently, is do a flat rate, but build a provision into the agreement that says that the fee could increase if there are unknown, later discovered assets, or if the workload exceeds what was anticipated at the time that the fee agreement was signed. So for the client, this leaves open some potential for surprises, and I don't like that. So for that reason, by far and large, we charge fees based on some variation of a percentage-based structure. As I said at the beginning of this episode, there are no perfect billing solutions. So the best suggestion that I can offer to you is to find an attorney who's reputable, preferably somebody who's local and someone who you feel that you can trust. So if you found this information helpful, please consider subscribing to the channel, and I'll hope to see you again in the next episode.